Hello, everyone. My name is Shrujna. I'm a PhD candidate at the Department of Political Science, and I'm going to moderate the session today. In the interest of time, we're going to get started as people continue to log in and join in the conversation. So on that note, I welcome you all to the Rockefeller College Lunch and Learn series. For our session today, we're pleased to have Professors Matthew Ingram, Julie Novkov, Katie Rader, and Tassiana Oliveira as panelists. Let me begin with a brief round of introductions of our panelists. Julie Novkov is the College Dean, a Collins Fellow, and Professor of Political Science and Women's, Gender, and Sexuality Studies at UAlbany. Tassiana Oliveira is Visiting Assistant Professor at the Department of Political Science at UAlbany. Tassiana has written extensively on public law and legislation and social reforms and constitutionality in Latin America, with a focus on the Supreme Court of Brazil. Matthew Ingram is Associate Professor at the Rockefeller Public Administration and Political Science departments. He specializes in public law, Latin America, and research methods. And finally, Katie Rader is an Assistant Professor of Political Science at SUNY Albany, where she teaches courses in the public law concentration. Katie's research examines the relationship between race and class in American politics and seeks to contribute deep historical and institutional explanations for the persistence of racial and economic inequality. So the topic for today is looking ahead, previewing the upcoming U.S. Supreme Court term. Our panelists today will review the key cases and constitutional questions on the docket for the upcoming U.S. Supreme Court term. This timely conversation explores the potential legal, social, and political impacts of the court's decisions and offers scholarly context for understanding what lies ahead. Before I turn it over to our speakers, let me go over ground rules. You are all requested to remain muted and hold your questions until the presentation is over. We're going to have time for Q&A towards the end of our panel discussion. You can use the raise your hand function on Zoom or send your question in the chat. If you would like to remain anonymous, you can send your question in the private message to me here, and I will read the question aloud. If you submitted a question in advance, I'm going to read it out. And with that, I'm going to give the floor to our panelists. Julie, why don't we get started with you?
Thank you so much. Thanks, Srinja, and thank you to the Rockefeller College staff who've organized this. It is great to be here with my three wonderful colleagues to try to sort some of this out for everybody out there. If you have been to previous iterations of this event, we've done it over the last couple of years, you will remember that we have generally started by talking about the major cases that the Supreme Court has decided that they're going to be hearing during the term, which starts, of course, on the first Monday in October. But I'm going to be talking about something a little bit different today, which is the work the Supreme Court does year-round on the so-called emergency or shadow docket. We usually focus most of our attention on the merits docket, which are those cases that come up to the court through the ordinary process of people appealing adverse decisions that have reached their final resolution, usually in the circuit courts, but sometimes in state Supreme Courts. But the Supreme Court can also step in when litigation is ongoing, but something has happened that demands a quicker response or a response before a suit has reached its resolution at the highest previous level. Now, over the last several years, if you looked at the emergency docket, what you would often see would be a lot of cases involving criminal appeals and efforts to stop bad things from happening, like the implementation of the death penalty or an extradition or some sort of criminal penalty. But in very recent years, we have seen the emergency docket taking on questions that have great significance beyond the impact on the individuals involved in the cases. So the Trump administration in the first Trump presidency began to use that emergency docket much more extensively to try to get its policies to go through. And that has continued with the second Trump presidency. So the context here is that when Trump came into office the second time in January 2025, it ushered in a wave of executive orders and actions by federal agencies, which then provoked a wave of litigation to try to block all of this activity. And the US district courts and circuit courts have by and large been pretty negative toward various administration agendas across different areas. And as these policies and rules and orders have been challenged, many of these district courts and circuit courts have put in place temporary orders blocking the implementation of these policies, while the litigation to determine the ultimate legality or constitutionality of these policies would be ongoing. And these have fallen into a number of different policy areas. There's been a lot of action around immigration, a lot of action around the administration's attempts to dismantle the administrative state, actions around funding and expenditures, around the president's power to remove individuals who have been appointed to serve in independent agencies, and then challenges to individual policies like the trans ban on military service, birthright citizenship. If we go back, I know we're supposed to be looking forward, but I do want to go back for just a minute. If we look at the 2024 term emergency docket, which ran from summer 2024 through summer 2025, we do see a real difference in what happens there after Trump returned to office. Usually what happens with the emergency docket is that the court is pretty unwilling to step in and intervene. Many of these petitions are not accepted. But for the Trump administration, they had a remarkable level of success. A political scientist, Adam Bonica, did a study on the broader context of litigation. And just for example, he found that the federal district courts had ruled against the administration 95% of the time between May 1st and June 23rd. At the same time, the administration went 15 for 16 in emergency petitions to the US Supreme Court. So between January and last July, there were 20 cases involving administration policies on the emergency docket, and 16 of them offered at least partial relief to the administration. The other notable thing about the emergency docket is that these decisions about Trump administration policies have been very divided. In only 2 of those 20 cases were there no dissents, and in 16 of them, at least one of the liberal justices dissented, and for several of them, all 3, Sotomayor, Kagan, and Jackson dissented. And overall, what we see with last year's emergency docket on the Trump administration is that the court allowed policies to be implemented or sent things back to the lower level for reconsideration under a more generous set of guidelines. So a lot of immigration policy was permitted to go into effect, although the habeas path of challenging individual actions was maintained. Independent agencies were allowed to go forward, and there are some hints the court is going to back Trump ultimately here. And the transformation of the administrative state was allowed to proceed, although the court again did lay down some markers for potential future challenges. So for this term, again, even though we are just a little bit past that first Monday in October, the emergency docket has been moving forward very aggressively. The emergency docket has already seen 40 petitions involving the Trump administration's actions. These are challenges by the Trump administration to lower federal court rulings that have gone against the administration. I'm sorry, that's incorrect. The 40 overall is the entire emergency docket with 9 pending. 10 of those 40, I'm sorry, are dealing with challenges to lower federal court rulings that seek to thwart the administration's agendas. And the court has decided 7 of those petitions. So they have continued to implement the transformation of immigration. So they've allowed the Trump administration to go forward with canceling temporary protective measures for certain nationalities. They have also lifted a federal court order that barred certain kinds of profiling of immigrants suspected of being in the United States without authorization. The administration has also continued to allow at least temporary suspension of funding in a couple of different contexts, including appropriated foreign aid funding and NIH grant terminations. And the court has been fairly sympathetic to removing independent agents. So they stayed the reinstatement of Consumer Protective Bureau members and stayed the reinstatement of one of the FTC commissioners. If you look at the reasoning, which you would usually want to do to figure out what the Supreme Court is doing, you're going to be kind of disappointed because the court has really not spent a lot of time explaining why they are making these decisions in the way that they are. So what you're seeing is very quick, simple orders. There have been dissents that have been a bit more detailed, but sometimes they will say, well, we're not really sure that this case is being brought by the right person or in the right venue. What this has engendered is increasing attention actually between the lower federal courts and the Supreme Court. Some federal court judges have actually gone public and spoken to the media about the lack of guidance that they're receiving from the Supreme Court. And the Supreme Court has been pushing back on that in opinions and elsewhere. There's a recent report of some comments by Amy Coney Barrett emphasizing that these cases are preliminary and the court doesn't feel any obligation to explain itself until it gets to the point of deciding on the merits. I just wanted to say a quick word about another case that I've been watching very closely on the merits, which is the Trump administration's attempt to alter birthright citizenship. This one will be coming before the court again in the near future, and the Trump administration has filed a brief that explains its position, which is largely that citizenship is more of a privilege rather than a right. So they're really imagining a wholesale reconstruction and re-understanding of the birthright citizenship clause in the Constitution. Happy to talk about that in Q&A, but I will now turn it over to my colleagues. Thanks.
Thank you, Julie, for your opening remarks. Tassiana, the floor is yours.
Thank you. Thank you. And I'm going to focus on one specific case that I think that we should all pay attention, which is Louisiana versus Calais. A summary of the case, beginning with the 2020 census, Louisiana's growing Black population revealed that although Black residents made up about 1/3 of the state's population, only one of six congressional districts was majority Black. In 2022, 2 groups of Black voters filed federal lawsuits arguing that the state's new post-census map violated the Voting Rights Act by concentrating Black voters into one single district. A federal judge agreed that the map likely breached the act. In January 2024, lawmakers adopted a revised map, adding a second majority Black district. Soon, white voters sued, claiming this new plan was an unconstitutional racial gerrymander. In April 2024, a divided three-judge panel struck down the map, but the Supreme Court stayed the ruling, allowing the new map to be used in the 2024 elections, where Democrat Cleo Fields, a Black candidate, won the new district. The Supreme Court first heard Louisiana vs. Calais in spring 2024, but later ordered re-argument for today, expanding the question to whether intentionally creating a second majority minority district violates the 14th or 15th Amendments. So my comments on this case. I'm interested in this case because I've been observing a pattern here. Lawsuits apparently designed from the bottom up to dismantle the legal architecture of the civil rights era and to construct what conservatives may call a colorblind America. I found a couple of years ago a good summary of this moment written by Professor Fingold from Boston University School of Law. The ideological alignment between right-wing litigants and the court's conservative majority, supermajority, means that what is lawful today could be unlawful tomorrow. So let's start looking at the litigants on the case in this analysis. When we look back at landmark civil rights case, we often have cases like Lovin versus Virginia, Brown versus Board of Education, so inspiring that people created books, movies about the litigants involved. In Louisiana versus Calais, the litigants seem almost anonymous. Until recently, we couldn't find public information on them. Just Sunday, I believe, there was a publication in the New York Times explaining where they come from, who are them. They discovered that several plaintiffs were Trump supporters recruited by lawyers to join the lawsuit against the state of Louisiana. Some said they didn't even know they were listed on this case. That finding then raises important questions. Were they affected by the redistricting? How? Who is really behind these cases and to what end? I don't have the answers, just questions. This brings me back to the idea of purposeful discrimination. After the civil rights era, the Supreme Court began rejecting many claims by Black litigants because they couldn't prove intent, that is, a direct conscious motive to discriminate. But then in 1982, Congress resolved this issue by amending Section 2 of the Voting Rights Act and creating what we now call the effects test. Under this standard, a law can violate the Voting Rights Act even without proof of intentional discrimination. It's enough to show that the results of the law are discriminatory. Then in 1986, the Supreme Court applied to this new framework in Thornburg versus Gingles, establishing the three Gingles preconditions that help determine whether a districting plan has a discriminatory effect, and that is being questioned here as well. So meaning plaintiffs must show that the minority group is large and compact enough to form a district, it votes cohesively, and the majority votes as a bloc to usually defeat the minority's preferred candidates. Now in Calais, the conservative justices could be flipping the script again, arguing that any use of race, even to remedy past exclusion, might itself be unconstitutional. That's what makes this case so consequential. And this is also part of a larger legal strategy. For some years now, we observe that the conservative legal movement has crafted theories, found ideal plaintiffs, and litigated step by step until those cases reach the Supreme Court. Ideally, we expect justices to decline to hear cases without a real injustice at stake, but today's court sometimes welcomes cases in which facts seem secondary. The focus has shifted from the lived experiences of discrimination to abstract claims about equal treatment, an approach that ignores how inequality actually works. When the Supreme Court first heard arguments in Louisiana versus Calais, it was about whether the state used race too much when redrawing its congressional districts. But instead of issuing an opinion, the justice took the unusual step of setting the case for re-argument, as I mentioned before, and they expanded the question. Now they're asking, did Louisiana's creation of a new majority-minority district meant to comply with the Voting Rights Act actually violate the 14th and 15th Amendments? That means the court could decide that even race-conscious remedies designed to protect minority voters are unconstitutional. It's a direct challenge to the foundation of the Voting Rights Act and potentially the next step in redefining anti-discrimination efforts as discrimination itself. So Louisiana versus Calais is not just another redistricting case, it's part of a decades-long campaign to recast equality law, to turn the promise of racial justice into what some people call, quote, reverse discrimination, end unquote. If the court rules that race-conscious remedies are unconstitutional, it could effectively destroy the remaining protections of the Voting Rights Act, following the path already started by Shelby and Brnovich. And we are witnessing an era where colorblindness is used to rewrite the history of color-based exclusion. And as that ideological project unfolds, cases like this become the legal framework of a post-civil rights America, one that treats race as irrelevant, even when the consequences of racism are not. So I think that's the debate that defines Louisiana versus Calais and in many ways the future of equality in the United States. That's all I have for
Thanks.
today.
Thanks, Tassiana. Over to you, Matt.
Thank you very much. I'm going to change gears here a little bit, and sorry, before I continue, I was having a little bit of trouble with my mic before. Can everybody hear me? Great. I'm going to shift gears here a little bit and talk about some of the criminal justice cases on the court's calendar for this term, but then also relate them back to the emergency docket that Professor Novkov was talking about. And also to some of the race issues that Professor Moura de Oliveira was discussing. In any given term, there's typically a couple of criminal justice cases that might address criminal procedure or criminal law itself. This year, there are 6 or 7 criminal justice cases, so this is a lot. And given everything else that's going on at the Supreme Court and around the Supreme Court, on the merits docket, on the emergency docket or so-called shadow docket, and in national politics generally, the criminal justice cases might fly under the radar, might get a little less attention than usual. So I wanted to highlight those. We could talk about any one of them, but I wanted to discuss 2 of the merits cases, 2 of the cases that will be fully briefed and argued at the court, and then connect them to some of the issues that are coming up on the emergency docket. So one of the merits cases comes up under the 4th Amendment. It's Case versus Montana. It's coming out of a town called Anaconda, Montana. And it has to do with warrantless searches or warrantless entries into one's home. The petitioner here, Case, was known to police. The police had had a couple of encounters with him previously. Once where he had threatened suicide, and another where the police thought that he was trying to provoke them into shooting him as a means of committing suicide. So the police were familiar with him. He's an Army veteran, and then the police received a call from his former girlfriend at one point in 2021 that she thought he was going to commit suicide at his home. So the police went to his home. They didn't get a warrant because they didn't think that there was anything criminal going on. They were just going there to assist him. And they spent about 45 minutes waiting outside or at the door. There was no response from Case from within the house, but they could see an empty gun holster, and they could also see what appeared to be a notebook where they say, or they allege, that they thought there might have been a suicide note. At one point, they enter the house to check on him under or justified by what they called, giving emergency aid, or under that urgency exception to the requirement for warrants, or the general rule about warrants. And they ended up encountering Case in his closet, and where one of the officers thought he saw a gun in his hand and shot him in the stomach. And then a gun was later found in that closet. But in any case, Case sued, arguing that the police did not have the authority to enter his house, right? That they should have gotten a warrant, that the requirement for entering his house under these circumstances should be probable cause, right? A sort of an elevated standard. But that the urgency or the urgent aid exception to a warrant only required reasonable suspicion. So the case basically boils down to, what standard do authorities need to enter a home to assist somebody or to provide emergency or urgent aid? Is it reasonable suspicion, a fairly low standard, or probable cause, a heightened standard? And one of the reasons that this case is interesting to me is that just as the court will be considering, what factors go into reasonable suspicion or probable cause, they just recently, on September 8th, on the emergency docket, issued a stay in the Nome versus Vasquez Perdomo case, which involved ICE detentions in Los Angeles. So going back to June, ICE engaged in an operation in Los Angeles where they were doing a lot of detentions based on, the lower courts found, based on primarily 4 factors: the apparent race or ethnicity of an individual, whether they spoke Spanish or English in an accented way, the type of location where they were found, and the type of job they appeared to be doing. All of these are troubling factors because they apply to large swaths or groups or categories of people. They're not particularized or individualized suspicion, the way a standard, or the way we would ordinarily think about criminal procedure requirements under the Fourth Amendment. And yet, in one of the emergency docket cases that Professor Novkov was talking about, right, where the lower courts said this was not okay, right, and ordered ICE to stop, the Ninth Circuit Court of Appeals agreed with the lower courts and upheld the injunction against ICE. When it came to the Supreme Court under the emergency docket, the Supreme Court undid that without any explanation, right? The majority did not explain why they were doing that, but basically then allowed ICE to continue doing these kinds of detentions. It's important to note that the injunction also only applied narrowly because of a previous emergency docket ruling, right, where nationwide injunctions are now no longer allowed. So these kinds of detentions, these kinds of actions are taking place across the country, and for any reasonable observer of the court's jurisprudence, they would violate are standards for how police could ordinarily engage in these kinds of detentions, right? They're supposed to be justified by specific articulable facts that are specific and individual in nature, right? Not that apply to whole groups of people based on their appearance. So there's that case that's coming up before the court at the same time that there's this. It's also important to note that the emergency docket is not a final ruling, right? It's not a ruling on the merits. So the lower case is still moving through the lower courts. But in the meantime, right, these enforcement actions, these detentions are allowed to continue. So I would encourage everyone to track that. That's something that I'll be tracking at the court, right? How as these cases percolate up through the judiciary, and I wouldn't be surprised to see the cases reach the Supreme Court again, perhaps even this year. How are the courts thinking about reasonable suspicion as in the context of these immigration detentions, and then how is the court thinking about reasonable suspicion in this other Fourth Amendment case that is already at the High Court? Another case that's up at the Supreme Court on the merits docket this year is Ham versus Smith. This case arises under the Eighth Amendment, under cruel and unusual punishments as applied to the death penalty. And here, there's a 2002 case, Atkins versus U.S., where the Supreme Court held that it was unconstitutional to execute people with intellectual disabilities, and there was a kind of a two-pronged test that was established for what constitutes an intellectual disability. That there's an IQ score of 70 or less, that seems to be the accepted threshold, but that an IQ score on its own is not sufficient. There also must be a more qualitative discussion or evidence of adaptive behaviors. So it's a two-pronged test, an IQ score of 70 or less plus evidence about adaptive behaviors. And Smith, who is the death row defendant in this case, has had 5 different IQ scores, ranging from 72 to 78. And the question here is, like, how should these individually be considered, right? Should they be averaged together? There's also a question that any individual score here has a margin of error. So typically, you would the margin of error depends on what test was used and when. But typically, the margin of error ranges anywhere from 5 to 10 points. So a score of 72 could actually mean that the real intellectual ability as measured by the IQ test ranges from 62 to 82, right? Clearly below the Atkins threshold of 70. But if these scores are then averaged together, which is what the Alabama state government seems to be arguing, then we should disregard the margins of error and just take the average. None of this says anything about adaptive behaviors. It's important to note. So this question seems to be revolving about how to consider multiple IQ scores. What to do when somebody on death row has multiple IQ scores. Connecting this back to the emergency docket, one of the typical things that used to show up on the emergency docket before this proliferation of cases arose under the Trump administration that Professor Novkov was talking about. One of the types of cases that were typical to see on the emergency docket are death penalty cases, right? Where death row inmates are sort of trying to challenge their execution or the manner of execution. And there have been multiple death penalty cases arising under the shadow docket or the emergency docket, or the interim docket as it's also known. And these are very routinely denied, right? Just as the court is extremely solicitous, right, and showing a lot of favorability to the Trump administration, it is routinely dismissing, right, sort of turning away these cases from individuals trying to address constitutional issues related to their execution, the death penalty, or the sentence itself. One case in particular is notable. This case arose out of Tennessee. A man had he's already elderly at this point, but he had an implanted cardiac defibrillator. So that would, he had congestive heart failure. So he had an implanted defibrillator that would shock him if he had any kind of heart failure. And the execution method by injection was going to cause this defibrillator to trigger, right, to try to revive him as he was being executed. So he was asking the court to allow appropriate personnel to be there to deactivate the defibrillator so that he wouldn't be in the process of being executed and revived, right, multiple times, right? So he wouldn't go through that process, which would be extraordinarily painful and essentially constitute torture under the Eighth Amendment, sort of as a cruel and unusual form of punishment. And there were also issues about his intellectual capacity that were raised multiple times. And as mentioned before, the court sort of routinely denied that case, and he was executed in August with the defibrillator implanted. And it did try to revive him several times.
Hey, Matt, I'm going to request you to conclude. We can come back to this discussion during the Q&A. Thank you.
Yeah, I was closing my comments there. I'll stop there.
Thank you. And Katie, over to you for your final remarks.
Okay, thank you all for being here. And I am going to talk a little bit about some executive power questions and specifically about the removal power in two particular cases. Now, as has been the case for many of us here, where we started off with Professor Novkov and the shadow docket because so many of the cases currently under consideration link back. And that is also true for these executive power cases. Both that I'm talking about today were at least conditionally discussed in the shadow docket, and many of the executive powers questions, separation of powers, questions about the limits of the executive power were decided more definitively through the shadow docket in the last year. A lot of this centered around major efforts by President Trump to reformulate, reshape the executive branch by removing executive agency heads, by firing members of staff, by getting rid of entire agencies. Now, the other thing I want to highlight, which has also been coming out in both Professor Ingram's and Professor Novkov's comments as well, is that these cases talk about the scope of presidential power, especially this removal power, but there's also an important additional question here that the court is considering about judicial power, namely the ability of federal courts to halt these kind of executive actions. So because the flurry of activity in these major actions taken with regard to the president, the Supreme Court is seemingly attentive in this current term to figuring out the bounds of what lower courts can do. I think we are likely to see some important refinements, possibly some broader changes. Think about things like limiting the use of nationwide injunctions by lower federal courts, which we've already seen. Okay, so the two cases I want to talk about, first, Trump v. Slaughter, and second, Trump v. Cook. I'll talk more about Slaughter and a little less about Cook, and then we can pick up on any of this in the Q&A. So the main question in Trump v. Slaughter, again, a case that has already seen some action on the shadow docket. However, in this case, the court did allow for the firing of FTC Federal Trade Commission member Rebecca Slaughter. The question the court is now considering as part of the merits docket is whether that removal was in line with the statutory requirements, right? So what's written into law about the removal of FTC members, and also more broadly, whether this kind of removal by the president is in line with the president's separation of powers And specifically, they're considering whether to overturn a previous decision back from 1935, Humphrey's Executor versus United States. Now, permit me here a little foray into the past. This case was also born out of political conflict. This was during President Franklin Delano Roosevelt's first term, where similarly the president, and Congress were really in a battle over who should have greater control over the federal bureaucracy. FDR maintained that he should have greater power to reshape the individual's part of his team. Congress asserted, though, that they should have the ability to set up agencies. And what they did in this case, they began creating types of independent agencies, which they categorized as independent regulatory agencies. Now, these agencies functioned in sort of a quasi-court, quasi-legislative mandate. And in ways, Congress created legislation around these to keep them more involved. And importantly, that legislation in many of these cases created a high threshold for remover. They set up staggered terms so that appointments wouldn't fall precisely along with the election cycles. And they also set a high threshold for removal, only in cases of inefficiency, neglect of duty, or malfeasance in office. All right, so in that case, Humphrey's Executor, the court ruled when FDR, he invited a member of the FTC to step down. That individual did not step down. He fired that individual. The court in that case back in 1935 said this had exceeded presidential power because FDR's firing had not aligned with that good cause. Now, one detail that I think is important about this case, one thing they did in that opinion back in the 30s was they parsed between different kinds of administrative officials. In a previous case, the court had said the president could fire the postmaster, the head of the USPS, because that was a role that fell more squarely within the executive branch. Now, I think that parsing is important and we have not heard hearings in this case, Trump versus Slaughter, about now contemporary firing of an FTC member, Rebecca Slaughter. Oral arguments have not been scheduled, although the court has accepted the case. I think that the court is somewhat likely in this case. Here I'm being careful about prediction, and I'm curious to hear what my other colleagues would predict here. I think the court is likely to overrule in this case. It's consistent with ideas about unitary executive theory, which is favored by Trump administration and also by some of the conservative appointees on the bench. Although I think it's possible and likely that they'll parse categories a little bit further, which links to just 2 minutes I want to say about the other removal case that has also been accepted as part of the merits docket that originated on the emergency docket, Trump versus Cook. This is a more recent development. President Trump attempted to remove a member of the Federal Reserve, Lisa Cook, for what he claims is gross negligence and claims that she committed mortgage fraud. Now, the other important piece of context here is that this is also in connection with Trump's very public and broader critiques of Jerome Powell and the Federal Reserve's resistance to calls by the president to fulfill different kinds of policy goals, namely among them lowering interest rates. Okay, so this was an exception, though, to the emergency docket decisions in that they did not allow for Cook's immediate removal. She is still in place on the Federal Reserve Board. The Federal Reserve is also one of those independent regulatory agencies, and the court has also indicated in some of those emergency petitions that it's likely to view the Federal Reserve differently. Here's a quote from another opinion. The Federal Reserve Board is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the U.S. So the lower court that considered Cook's challenge found two main problems with her removal. One, that it violated statutory requirements and stipulations for cause firing, primarily because the conduct, the alleged mortgage fraud, whether or not it's true, occurred prior to her tenure on the Federal Reserve. And the second issue with her termination was that she was not afforded fair opportunities to challenge this. So the Supreme Court's likely to consider both this presidential removal power and the stay put in place by the lower district court. I'm even less confident about any sort of prediction here. I think that the court seems somewhat likely to continue to preserve this unique carve out for the Fed, but they could find ways again to parse the categories, weigh in on these fraud allegations in some other kinds of way that allow them to keep this Federal Reserve carve out, also allow Trump to fire Cook. And I think in this case, we're also even more likely to see interesting, important rulings on the scope and nature of lower courts to weigh in on these kind of cases. All right, with that, I will conclude though. I'm sure we have more questions and I'm looking forward to hearing other comments.
Thank you, Katie, and thank you to all our panelists. With that, let's open it for Q&A. I'm going to request you to please use the raise your hand option to ask your question, and I'm going to call your name. And in the meantime, while you're raising your hand, I'm going to ask a question that came to us in advance of the session. So one of the questions from an audience is, and I'm going to ask any of the panelists to please take it up. So the question is, do you see this term being one where the Supreme Court justices vary their decisions from long-standing precedents?
I would say certainly on some issues. Voting rights seems like one where we could see some substantial changes. As Matt noted, there are likely to be some shifts in how we think of criminal procedure. I do think the court is likely to continue the path that it has forged with regard to religious free expression and establishment.
Would anyone else like to add to that from our panelists? Or I can move to the second question. So the second question we have that came in advance is, what can or should we be doing as young adults to minimize the negative impact of Supreme Court decisions which alter the precedent unfavorably? And among the examples is, Dobbs versus Jackson Women's Health verdict decided in 2022 that struck down Roe v. Wade that was passed in 1973.
Well, I would say, first of all, don't forget that the US Constitution is not the only Constitution in the United States. There are state constitutions that have rights guarantees that can be activated, and the states, at least thus far, are able to set their floors at a higher level than what the federal government chooses to do.
I would also say part of the court's answer in Dobbs versus Jackson Women's Health was that it wanted to turn this question about abortion protections and limitations back to the states. And I think that dovetails nicely with Julie's comment just now, which is that means, and many states have, I think, have moved in, depending on your opinion about the outcome of that case, have moved both in directions consistent with the ruling and moved in directions that push back against the ruling through state level constitutions and state level amendments.
Just building on what Professor Rader said, depending on your perspective, you might take different positions on specific rulings. Dobbs being one example, but also other cases. One of the things that I think many observers of the current context find preoccupying is that there's an increasing number of issues on which people on both sides of the ideological spectrum should probably agree, right? And those are the changes that are eroding some of the core democratic institutions or institutional arrangements, like the separation of powers that Professor Rader was mentioning. So if that is preoccupying to you, I would encourage folks to just stay informed and get involved.
Can I just add a final idea? Just remember that institutions, and especially legal institutions, can only do so much. So it's another way of accountability is social accountability. And remember, the institutions are made by people. So you are also part of this scenario, this picture.
Thank you. I'm going to request Professor Koslowski to ask his question, and then I'm going to request Jason Roby to ask the question, and then the panelists can respond to it together. Thank you.
Okay, a question for Professor Rader on the cook removal case. As far with this, the mortgage fraud allegation, I don't know what happened to this notion that people are presumed innocent until proven guilty in a court of law. Are allegations sufficient to become the basis for this kind of a removal?
Jason, can you unmute yourself and ask your question? And then we're going to request the panelists to respond to both the questions. Thank you.
Yeah, sure. So my question is just kind of generally about, it seems like this particular term or the last couple of terms of the Supreme Court have seemed particularly sort of hectic, and there's a lot of big issues that are being challenged. And I'm wondering if the panel could talk about the extent to which that's reflective of a change in the composition of the court, or if that's a change more so in the strategy of the presidential administration and how they're sort of seemingly just throwing lots of sort of things at the wall and seeing what sticks. Because it seems to me that it's more of the latter than the former, but I would be curious to hear. And also just about the gamification of this system, right? Matt talked about the national injunctions ruling, right? And there was some talk I heard around the time that this would potentially just lead to the Trump administration essentially accepting losses and not even trying to appeal them to the higher courts because they sort of get a half win out of it anyway. So I'm just curious about the tension between how the court responds and how the Trump administration sort of pursues a certain legal strategy.
I can maybe start with some speculations, right? I don't think I have a very good answer for you here. And part of this, I'm curious to see what the court says. You know, it's possible that they are tentative and anxious to address something like what you're raising, which is what kinds of allegations can be allowed and what kind of allowances will they make for sort of circumventing other kinds of processes for making these determinations. Now, they could skirt that issue entirely. I don't really know. I don't know if others have predictions. I'd be curious to hear.
I don't think I can add too much to that. I think we're just going to have to wait and see. But Jason, I think in some ways it's both. I think that a lot of what we're seeing on the emergency docket is being driven by the administration, but it's also being driven on the front end by the actions that the administration is taking. And then on the back end by the administration's appealing of all of these preliminary rulings that are going against it. But the larger context is the rise of juristocracy in the United States, as in many other places in the world, where controversies increasingly do tend to land in the courts. The interesting twist that we're seeing right now is that rather than having the Supreme Court defending its authority and superior power against the other branches of government, it's doing it against the lower federal courts, which is, I have to say, a form of juristocracy that I didn't see coming.
Yeah, on that last point. No, go ahead, Tassiana.
No, I was just going to comment to Professor Novkov's comment right now. It's almost like the judicial backsliding, the attack on courts is coming from the court. So instead of having that coming from the executive as traditionally.
Yeah, and one other thing that is just building off of what Professor Novkov just said about the the Supreme Court or the High Court attacking the lower courts. It's a way of verticalizing power, right? So power is concentrating in the executive as Congress recedes and does very little, and as the High Court is deferential to executive power, right, and allowing a lot of these, issuing these stays of lower court orders, but then also diminishing the importance of factual findings or rulings done by the lower courts. And one thing that I have not seen, Professor Novkov and I were talking about this recently, but I do not recall seeing, in at least in my recent memory, is the amount of public complaints made by lower court judges.
Mhm.
That's highly unusual.
I
I
just
think,
wanted to take a
sorry,
quick
go
stab
ahead.
at Joel Harmon's question, which I think is a really interesting one about looking at originalism in the context of these actions that the court is doing to support an executive that certainly looks far more powerful and far more encompassing than anything that the framers would have been willing to accept. I always point out to my undergraduate students that the framers put the articles of the Constitution in the order that they did for a reason. There's a reason that Congress is Article 1, the courts are Article 3, and then the executive is in between them, with the imagination that Congress is really going to be the dominant body here. I think having read some of the deeper conservative explanations of what's going on, if you want to take that argument as a genuine one, what they would say is that they want to see a unitary executive that is really controlling and commanding all the functions of the executive branch. And what has happened since the New Deal is the proliferation of independent agencies and administrative bodies that are not under the control and authority of the executive branch. And what the Trump administration is trying to do is to pull all of that together back under the executive in a way that would be far more recognizable to the framers than the system that we have in existence now. However, the complete empowerment of that executive, I think, is a little bit more difficult to argue as on an originalist basis.
Just maybe one thing to add to that question. I think there's also, I have been following some of I don't think they have a decision this term, but the Loper-Bright Enterprises decision overturning the Chevron doctrine, which spoke to this sort of separation of powers relationship between agencies and Congress. So actually in that case, in that overturning, perhaps I think using textualism, right? Maybe textualism is doing some work here, but there the court said, no, agencies require and must have really explicit authorization from Congress in order to be able to enact particular policies or implement particular policies. So that's, I think, just an interesting sort of counterexample. If you look at another separation of powers relationship, and the court actually elevating its own role in making those determinations, I think is one of the main consequences there. So
they're very good at dealing themselves in.
Yes, they are, aren't they?
I think we've neared, the time to close our discussion, and I was hoping we can close with the last question that came in a chat, and it's a simple yes and no question. So hopefully we can, close our lunch and learn today with that. This has come specifically for Professor Novkov. So the question is there any limit to the number of cases the court takes up in the emergency docket, and if so, who sets that limit?
The justices themselves. And anybody can file one of these petitions. They're going to take it more seriously if it's coming in the context of a case that has broad public significance, or if it's coming from a powerful actor like the administration. But they choose. They get to choose whether they're going to handle these and the way in which they're going to handle them. They can simply not really act on them. They can reject them with no real discussion and just put in an order, or as we've seen, they can take them up and have a more robust discussion among the justices that could produce some dissents. But they can continue to operate in this fashion, limited only by their preferences.
Thank you. And with that, we have come to a close for today's event. I just want to quickly remind you all that our next Lunch and Learn will be next Wednesday on October 22nd. So I'm going to be looking forward to seeing all of you. I want to thank our panelists and all of you for attending today. Thank you. Have a good day ahead.
Thank you, everyone.